Yeah, thank you, Erica. So before we begin, I would also like to acknowledge that I'm joining from the unceded and traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, from what is today Vancouver. So as a brief introduction, I work with the Ministry of Housing and Municipal Affairs as an analyst with the Homelessness and Supportive Housing Policy Branch. I'm joined by some ministry colleagues from the Housing Policy Branch, as well as the Residential Tenancy Branch. And these colleagues have partnered in the development of the changes we're going to present today. Also want to take the time to thank BCNPHA, Erica and Courtney for hosting today's meetings and other meetings. I think it's really important. And so today we'll be presenting on the amendment authorities and process. This session is one of a series we'll be having and does not explain changes around weapons or restrictions of access. Those are coming up. So I think Erica has alluded to this, but the presentation may be technical and at some places repetitive. There's a lot of heavy material. I will do my best to let you know when a slide contains information you may want to pay more attention to than others. I'll be happy to circle back to any element in the slides that may have been missed. So there's a good amount to cover. I don't know if this was mentioned, but we have time set for questions, of course. And what I would ask you is just to hold the questions until the end. So sometimes the slide will answer something that you might be interested in. So we hope the information shared today will prove helpful when staff may reach out with questions or for directions. So to start, just an overview of today's presentation. Our objective will be to present and explain what is changing under the Residential Tenancy Act and why, when these changes are coming into force and when they will become effective, what this means for providers, looking at implementation and the time-limited amendment authority. We'll delve into process requirements and provide information about what to focus on and action. And finally, we'll wrap up with the immediate next steps. So to this last point, the key takeaway from today's presentation should be that supportive housing providers need to review and update tenancy agreements to ensure that when the Bill 11 changes become effective, they'll be able to benefit from them. So before we dive into the technical aspects of the changes themselves, I want to underscore that the following presentation applies to supportive housing and supportive housing only. It will not apply to shelters or transitional housing, assisted living, residential care facilities, or regular market housing. So when we speak about new provisions becoming effective December 1st, 2026, and about the requirements to update tenancy agreements ahead of that date, we're not speaking about transitional housing program agreements. And I understand for mixed use buildings and for operators who provide both types of housing, the takeaway may be different. It is that changes will apply only to the unit that is operating as supportive housing. So these changes fall under the RTA, which applies to supportive housing, and some providers operate programs that may be difficult to classify, especially where housing includes structured programming, recovery-oriented services, clinical supports, or transition planning. In broad strokes, transitional housing can be seen as time limited, and supportive housing can be regarded as long-term or permanent housing. So the upcoming changes do not, I would like to underscore, do not create a determination of whether program agreements can be created or whether transitional housing is operated. They don't delve into that. Whether a unit is subject to the RTA is ultimately determined by the nature of the housing arrangement and the definitions in the Residential Tenancy Act, not by what type of agreement is used. So calling something a program agreement does not automatically exempt it from the RTA. So that's just a little bit of a heads up. Providers who are unclear whether they operate under the Residential Tenancy Act should continue to seek legal advice regarding their circumstances. As a best practice, it would be important to ensure that program agreements have terms on wellness checks and guest policies in your program agreements, which many operators already have. If there were a dispute that went to RTB arbitration, Royal Residential Tenancy Branch arbitration, or an arbitrator decided that a unit was actually supportive housing when an operator thought it wasn't, the program agreement in place would be treated somewhat as a tenancy agreement. In that situation, a provider would still be able to use the new tools under the RTA and carry out wellness checks as long as they have guest policy or wellness check terms in the program agreement that comply with the RTA. So it is a provider's responsibility to amend the program agreements they're using if necessary and in a way that is lawful and appropriate. These RTA amendments can't grant providers authority to amend what may be transitional housing agreements as they are exempt from the Residential Tenancy Act. So should you be operating transitional housing and choose to update your program agreements, you should not use the RTB form that we're going to be presenting on. The RTA doesn't govern providers' authority on how they amend their program agreements. So what I would like to underscore is kind of not to assume that calling an agreement as a program agreement will make it outside of the RTA, but also to really look at the type of housing. Now, we recognize that there is a genuine uncertainty for some providers. Some programs have transitional features, some have supportive housing features, and some may fit neatly into either category. That uncertainty is real, and we want to acknowledge that. And just to inform you that the ministry is continuing to work to clarify transitional housing and distinguish it more clearly from supportive housing. At the same time, we also recognize that waiting until transitional housing questions are resolved would delay the urgent safety-related changes for supportive housing that have been identified and urgently requested by providers. One of the ways in which jurisdiction is currently being determined is through the RTB dispute resolution process. If a future RTB decision results in a finding that a unit is supportive housing, then the RTA framework or the Residential Tenancy Act framework would apply. Terms that conflict with the Residential Tenancy Act in this case would not be enforceable, but terms that are consistent with the Act may continue to apply. We'll circle back to this at the end of the presentation to talk about next steps in each type of these scenarios, but the main takeaway is really to have terms that align with your operational needs. So with that said, what is changing? So summarily, regulations are being amended to bring new provisions introduced through Bill 11 into force. Bill 11 created new tailored provisions under the Residential Tenancy Act for supportive housing, specifically to enable landlords to address immediate safety risks. Notably, the provisions will allow supportive housing landlords to seek an end of tenancy when a tenant or a person they've permitted on the property has a weapon, and temporarily restrict a tenant's access to the residential property in limited situations where the tenant has created an extreme risk to others. These provisions will become effective as of December 1st, 2026, at the end of this year. So as part of this work, providers will need to update their tenancy agreements to ensure terms align with the new provisions before they become effective. So this is a slide that I think would be of interest to capture. So the upcoming regulatory amendments that we're making will create an exceptional time-limited amendment authority for supportive housing providers to update their tenancy agreements. So there are 3 dates to remember here. On July 30th, the implementation window opened. On October 26th, the implementation window closes. And on December 1st, the new provisions become effective. So the most important piece to keep in mind is that the time limit amendment authority ends on October 26th. Missing this implementation window can have serious consequences, including the inability to amend existing agreements without seeking a tenant's written consent, being non-compliant with the Residential Tenancy Act, or being unable to comply with obligations under an operating agreement. Here we're talking about wellness checks or health and safety checks. So what is the temporary or time-limited amendment authority? The temporary amendment authority is an exception to the general tenancy agreement amendments rules that have been created specifically to support implementation of the changes introduced in Bill 11. The aim of this authority is to ensure that landlords, supportive housing, have the ability to update their existing tenancy agreement terms to align with the new provisions. During the implementation window, providers will be allowed to amend certain tenancy agreement terms without needing to first obtain their tenant's consent. So this authority can only be used for updating terms related to the new provisions that will be effective December 1st. Here we're talking about the weapons provision, the restriction of tenant access, and landlord entry. For terms related to wellness check and guest management policies, and for terms for occupant limits. So a key takeaway here is really that as providers, you do not need a tenant's signature for these specified amendments to apply and be effective, but you still need to notify tenants of the changes and keep records. So if we look at how providers can amend existing agreements and the steps that could be used, could be separated, the steps could be used to achieve this before October 26th. We're really looking at here as an initial step to review current tenancy agreements and current tenancy agreement templates that are used, reviewing existing tenancy agreements and any tenancy agreement templates will allow providers to identify the terms that relate to weapons, tenant access, landlord entry, guests, occupants, and wellness checks, and also identify where these may be missing or out of date. Step 2 would be for providers to remove or change existing terms relating to weapons or landlord entry into the unit that are inconsistent with the new legislation and new standard terms that apply as of December 1st, as well as draft or update additional terms for wellness checks, guest policies, and occupants. These should meet operational and tenant needs. So providers will have the option to use guest management and wellness check terms that have been drafted by BC Housing for this purpose, or can modify and draft your own terms. Providers should ensure that all guest management, occupant, and wellness check terms are consistent with the law, clear and understandable, fair and enforceable. This could involve obtaining legal advice, and that is recommended when needed. So from July 30th, but before October 26th, providers should ensure their tenancy agreement templates and documents used to create new tenancy agreements are updated to reflect the added and amended guest management, occupant, and wellness check terms. And by December 1st, landlords should ensure that their tenancy agreement templates or documents used to create new tenancy agreements are updated to be consistent with the new provisions, the new standard terms under the new legislation that will be effective December 1st. And so step 3 is really about the amendment process that we're going to cover over the next slides. So between July 30th and October 26th, supportive housing landlords or providers must serve all current tenants with the 30-day notice of tenancy agreement amendment form. And I'll come back to the official title of that form. The form will include the new standard terms for supportive housing. Those are already there, with space for providers to add or amend other additional terms. A provider should review and complete all sections, must review and complete all sections of the notice, sign and date the notice, and keep copies for their records. The takeaway here is that informal, verbal, or non-standard notices won't satisfy the legal requirements that we've created for the amendment process and may result in non-compliance with the law or ineffective amendments. Notice must be served during that July 30th to October 26th window. And service of that notice must be made in a recognized method. And we can come back to that if you're unfamiliar with the methods of service under the Residential Tenancy Act. Now, a key takeaway as well is that tenants will have questions about the amendment process and will benefit from communication about the changes. And they'll benefit from a language that they can read and understand when understanding the notice. So although it's not legally required, we have created a tenant FAQ and developed it for this purpose. It is a notice or a form that you could add to the notice to accompany it so that changes can be clearly communicated with tenants. Another thing to underscore is that documentation through this process is important and may be needed to demonstrate compliance with the RTA. This is should a future RTB dispute arise. So providers should maintain a proof of service of the notices and keep records to support that they've made the necessary changes. These records will show compliance with amendment requirements. They'll protect against future disputes. And for tenants, this is also an opportunity to have records if they request them. So as an immediate next step, providers should review supportive housing tenancy agreements to identify what terms they intend to update. This step is crucial to determine what terms need to be added, removed, or modified to ensure that they are consistent with the new standard terms and that you have additional terms that are required for your operational practices. So on this slide, we've
There is
separated,
no slide.
there's no slide, sorry.
Nope. I'm sorry. Am I the only one who can't see slides?
Sorry, I'll jump in here. So it looks like for a handful of people who are audio only, you're not seeing the slides. I think there's a lot of folks who can see them, but there are some people that can't see them for some reason. Sorry to interrupt you, Leon. We've been trying to deal with that while you're presenting. For people who can't see the slides, it seems to be an issue with if you're coming through either Edge as a browser or just in general you're using the app, like sorry, the a web browser as opposed to the actual Zoom app. So if you can log in and use your desktop app, you should see your problem resolved. If not, I know some folks had switched to use Google Chrome instead of Edge, and it seems to have resolved itself. It's something to do with Edge or just your browser. Apologies for that, where this is not an issue that I've seen before, so it doesn't seem to be a feature that we can turn on or off.
Yeah.
Courtney, did you have anything to add?
No, so it'll just be the folks who, if your bottom screen on Zoom looks weird, for lack of a better word, like if you're not used to seeing the same normal buttons that you normally see, or you're not able to turn your camera on and off, this will be you. If you can turn your camera on and off, you can see the screen, then it's not, you're not one of the select few that Zoom has been fighting around. So don't worry about turning your camera on. If you've been able to see the slide, then this doesn't apply to you, so it's all good. And you turning your camera off will not influence you being able to see the slides or see other people. There's just a couple of people in here who are joining in without the ability to turn their camera on and off who are not able to see the slides. So if this is you and you'd like to see the slides, like Erica said, try joining in on a different browser or logging in on the desktop app. Because it's going to be from your end. Zoom is deciding that your internet is not strong enough or there's some security settings or something. So
And there's been a couple people messaging me that I literally can't respond to. So it might be if you want to email me, that might be the fastest way than us pulling your registration. Because now it seems like people need the meeting ID and passcode potentially,
mhm.
if the link isn't working. So I think at this point, Leon, you can just keep presenting and just a reminder that it is being recorded. So I'll get this out to folks. So if you've missed it and need to rewatch it, apologies for the technical issue. It's very strange and I don't know how to change it en masse. But yeah.
I'm also going to post the Zoom link and passcode into the chat right now for some folks, if they're able to like copy and paste that if it's an issue.
Thanks, Courtney. Sorry, everybody.
Sorry for that.
We can't get to the chat either, so
Yeah, I'm not sure why it's limiting. It seems to be again from where you
yeah.
access the meeting, but for
Okay, but I need your email.
It's just ERIKA at bcnpha.ca.
And we can circle back also to some information, I have no doubt. We'll have
Yeah.
So within the process, an immediate next step would be to review supportive housing tenancy agreements. This is reviewing existing agreements and templates to identify what terms you intend to update. So this step is crucial to determine what terms need to be added, removed, or modified to ensure they are consistent with the new standard terms, as well as additional terms. On this slide, we have separated the areas of focus into additional terms and standard terms, and I've been using those words kind of back and forth, but there is a important difference. So we'll look at the difference, and the main takeaway is that it'll be important to identify the terms that are related to the areas, again, of focus, which are weapons provisions, access restriction provisions, landlord entry into the rental unit, wellness checks, guest management, and occupancy limits. Understandably, some providers will have recent tenancy agreements that may include terms about wellness checks or guest policy and may not need to include, change, or remove additional terms related to these areas. However, the obligation is still there for all providers to notify their tenants of the new standard terms, meaning that the notification process will be required even for these new agreements. For this reason, best practice is to review all tenancy agreement terms to ensure that they are RTA compliant. Adequate review of the tenancy agreement is the best way to ensure that the terms are Residential Tenancy Act compliant and is also an opportunity to ensure agreements support the day-to-day operations in case terms were missed. So once review is completed and terms are identified, it's time to move to step 2, and we would be aligning terms in the new tenancy agreement templates. So to help understand the drafting requirements for terms, it'd be important to distinguish again the two categories, the standard terms and the additional terms. So new standard terms, first, these are terms that are, as the name states, standardized. They're established by regulation. They are already drafted and can be found in the schedule of the regulation, as well as on the approved notice of amendment form. These will be terms that automatically apply. They will be effective December 1st. So for the standard terms, the takeaway is there's nothing to draft. They're already there. They're on the form. We look at the additional terms. These terms are not standardized. They'll vary between providers. They're established by the parties. In this exceptional case, they can be established by the provider only, right? You don't need the tenant's consent. They do not automatically apply, then that way they're different than standard terms. We'll touch on why this is important in a moment. And they can be effective earlier than December 1st. It really depends on when and how the notice of amendment is served that includes these new additional terms. And so this table shows the category of terms by subject. So as you can see that the standard terms apply to weapons possession, temporary restriction of tenant access, landlord entry into the rental unit. Those are the terms that don't need to be drafted. And then the ones that you may need to draft or may not if you already have them are the terms with regards to wellness checks, guest management, and occupant limits. So the key takeaways are really no drafting requirements for standard terms. These terms will be the same for all supportive housing and are outlined in the regulation. The RTB form already includes these. If you have the link in the message that was sent out by BC MPHA or BC Housing, take a look. If you don't have the link, we'll be able to pop that in the chat later. But you'll see that those terms are there. And on the coming slides, we'll just show briefly what they look like. And drafting of additional terms is where the bulk of the work will lie. Additional terms will vary based on the tenant's needs and programming and operational needs. So here we're talking about terms related to guest management, wellness checks, and occupant limits. So the good news is that drafting for many providers will really only be about those 3 areas. As well, to support, BC Housing has already created the operational standards related to guest management and wellness check policies with some guiding principles that providers can refer to in developing their policies, as well as for this amendment process, they've created templated terms with regard to guest management and wellness checks. And those can be used as a base to work from or can be used and copied in. So as a quick overview, the following slides will just show the standard terms for weapons, restriction of tenant access, and landlord's access to the rental unit. All of these terms automatically apply and become effective December 1st. So here, if you look at the slide, we've highlighted a few areas as there may be curiosity, and we're going to present this in more detail on Friday about the weapon provision. But a weapon is defined by regulation, and possession is personal possession or can include plain view discovery of a weapon where a staff or provider is lawfully in the tenant's rental unit. So on this slide, you will notice that the term prescribed is repeated often. This refers to changes not yet finalized that will be effective December 1st. So should you receive questions from staff or from tenants about when and why the restriction can occur, you can share only that the restrictions are set by regulation at this stage, and we'll have presentations and materials about that shortly. Operational guidance related to this change, the restriction of access, and the weapons policy will be provided later in the fall. That'll be much more exhaustive than what you've already received as far as fact sheets related to these changes. On this slide, I'd like to bring your attention to the new standard term for landlord's entry into the rental unit, which is very similar to Section 29. Now, you may be asking yourself, well, if in 2024 we were exempted from Section 29, why do we have this now? And paragraph F would be of interest. It allows a landlord and tenant to stipulate other reasons for entry. And here you could add additional terms into the tenancy agreement that would authorize entry for wellness checks or for decluttering or for other operational practices. Here it's important to note that F does not create the reason for entry, nor does it provide kind of a carte blanche, no rules reason for entry. You really would need to develop your term and ensure that it meets a reasonable standard and that is written in a way that can be enforceable. And for that, again, BC Housing has provided templated terms that can be referred to. So when drafting additional terms, these are not standardized. It'll be important to keep Section 6 of the Residential Tenancy requirements in mind. And under the Residential Tenancy Act, to be enforceable, a term cannot conflict with the Residential Tenancy Act or regulation. It cannot be unconscionable or grossly unfair, and it has to be written in clearly enough that tenants can understand their rights and responsibilities under it. So not expressed in a manner that clearly communicates the rights and obligations it contains. What that really means is we're looking at the standard person, if they do exist. And so when looking at that, understanding the tenant needs will vary, you'd be really looking at kind of the standard tenant. BC Housing templated terms have been developed to assist providers in drafting effective terms. They're a starting point. You may have operational practices or programming that require your terms to be drafted differently. You have also a residential tenancy branch. They have resources. They have online policy guidelines that are available to help providers when developing terms that are reasonable and enforceable. And here the key takeaway is really, if a term is unclear, unfair, or inconsistent with legislation, it may not be enforceable. So if you have a doubt about the terms you drafted, you could seek legal advice, and you could contact BCNPHA and see if they're able to help you find support in that regard. So once the tenancy agreement and related documents have been reviewed and that additional terms have been drafted, providers should take as a first next step updating their templated tenancy agreements and related addenda. The idea here is to capture any new agreements, so the sooner the better, so that you won't need to serve the amendment form again during that window. As a reminder, from July 30th, all new tenancy agreements must include new standard terms. So those are on weapons, tenant access, and landlord entry into the rental unit. And they should also include the additional terms needed for our operators to be able to conduct wellness checks or follow guest management practices. Now, if a tenancy agreement has been entered into since that July 30th date, then standard terms will automatically apply. However, you may need to use the amendment process to add, remove, or modify any additional terms related to wellness checks, occupants, or guest management if you don't have those. Including updated terms and new agreements will really ensure that all new agreements meet the legislated requirements, that the new agreements reflect the programming and tenant needs of your site, and that the use of the amendment process will not be required, so you don't have to create kind of a duplicity. So finally, step 3. And here we're looking really at the amendment process for existing agreements. For existing tenancy agreements, providers must fulfill amendment and notification requirements. The legal requirements are as follows. Notice must be in writing and must be on the approved RTB form with all fields completed. Service must comply with recognized and allowable methods of service under the Residential Tenancy Act. Now, if you're looking at the Residential Tenancy Act later, you're looking at section 88 and 90. And they have to also, service has to occur during this implementation window, during this limited time frame for the limited authority. Although all steps in this process are important, it's here that an administrative planning or implementation planning will be really important to ensure that staff act within the implementation window to avoid errors, duplicity, and keeping records. So the legal requirements establish a basic process. However, creating an approach to update your tenancy agreements will affect your success. As part of this work, we encourage you to be aware of the service methods and deemed receive dates that are set out by the Residential Tenancy Act, and those we have here on the bottom of the slide. It's an overview of what we call deemed receipt dates, which are a legal fiction for when something is received unless it's proved otherwise. It's a very high-level slide. If you're interested in more information about service, you can also look at policy guideline number 12 from the Residential Tenancy Branch. We strongly recommend that you familiarize yourselves with this policy guideline, including the sections about email service. Some key elements to remember are that notice requires the use of the mandatory form. All necessary fields on the form have to be completed. Failure to properly complete the RTB form can have the consequence that the notice is going to be legally ineffective. Proper service is essential. Notice served incorrectly will create issues later, and that could create a dispute, and it could also affect whether or not an additional term is included in the tenancy agreement and deemed effective. And we're thinking of guest management, wellness checks, and occupant limits when we're talking about those terms, because again, the standard terms will automatically apply. And lastly, records and documentation are crucial. And we'll circle back to this shortly, but the key takeaway here is really having an implementation plan, and this may vary from site to site or from provider to provider, will be very helpful. So on the last slide, we kind of mentioned the importance of understanding service provisions. This is particularly true if we're looking at when terms that are additional terms become effective. So those weapons, landlord entry, and restriction of access terms will only be effective on December 1st, but it is possible using this process to add additional terms with regards to guest management, wellness checks, or occupants that can be effective before that date. So the reason that new standard terms are only effective on December 1st is that it's set out by regulation. Additional terms become effective, though, based on when a notice is served and when it's deemed received. So we would strongly advise that you pay attention to service dates and then the deemed receipt rules. On this slide, we have kind of a simple way to calculate the effective date that additional terms can have. The formula would be the date the notice is served. Then you add the deemed receipt date. That's based on section 88 and section 90, or the past slide, the different methods of service. And then you add, of course, the 30 days that are on the notice period of the form. And this will help you determine an effective date. So if we were to run an example of this calculation, if a tenant was served notice by registered mail on August 1st, we would take the date of service, that is August 1st, and we would add 5 days to obtain the deemed receipt date, because the deemed receipt date is 5 days after, and so August 6th. Next, we would add 30 days for the 30 days of notice established by regulation, and we would obtain the effective date of September 5th. So if a tenant received that notice on August 1st, and they were served registered mail, without going too much into the technical aspects, those terms that are added, that are additional terms, could be effective on September 5th. So a key takeaway here is, again, distinguishing between standard terms and additional terms. And so standard terms are only really effective on December 1st, whereas additional terms can be effective earlier. And again, I can't overemphasize this. Creating an implementation plan will be incredibly helpful. This is a way to create a manageable approach to service. This could include breaking the work down by building, by floor, by tenant list, and service method, as well as looking at determining dates when maybe the service can occur, right? When will you have the amount of staff for this? Are there certain days that are better than others? And again, the approach to serving notice may vary based on the size of providers. So each site should have its short implementation plan as a best practice that staff are aware of and that identifies the number of tenants that are being served, the service method that is being used, the staff assigned to serve, and document service, dates for service, and possible follow-up. Some tenants may need a follow-up. A short list of tenants that need this additional engagement and support before and after service will be helpful. So staff may ask you about this process, what needs to be documented, why things need to be documented. The basic idea is that providers should always be documenting and keeping records, which I have no doubt you do. And the reason for this is to demonstrate compliance, show that the legal amendment and notice requirements have been respected. This affects the whether or not the terms are enforceable. It also protects against disputes. More documentation, including that tenant FAQ, can be helpful. So providing clarity for staff about what additional terms are applicable and when will help them with their operational practices. This helps if you're carrying out wellness checks or restricting guests to know exactly what the rules are. And again, great records help when tenants request records and request that information. Transparency is helpful and key here. So having a reliable record to refer to is a great way to de-escalate any type of tenancy agreement conflict. So what happens if providers don't update agreements? Well, the simple answer is that you'll face operational challenges later. This could affect the enforcement of guest policies, occupant limits, wellness check policies, and could limit the new weapons-related authorities. So earlier, we showed the highlighted spot on the weapons provision where there's this idea of plain view discovery in a rental unit. Well, that plain view discovery is based on the idea that staff are in the rental unit with a legally defensible purpose. And so not having the right terms about guest management or wellness checks, more specifically, could impact this. So providers should look to ensure that any new tenancy agreements have updated additional terms. I'm sorry if I'm being repetitive. We're kind of trying to hammer the messaging here. And then also be aware that new standard terms should be included that are effective December 1st. So maybe the key takeaway is that this is a one-time implementation window. It's very exceptional. You don't need tenants' consent. You don't need to rewrite an existing tenancy agreement. The updates are really for your tenancy agreement templates or amendments for your existing tenancy agreements, and that are done through the notice. So please don't wait until the last minute. I don't expect anyone on this call to, but I would prioritize the review as soon as possible. And so to ensure that you're able to meet the requirements of the amendment process and update agreements ahead of the changes, again, it's crucial to have an implementation approach for your teams and sites. So as you update tenancy agreements, please keep in mind that the agreements entered into from July 30th are going to include these new standard terms and should include any additional terms you need for your operational practices related to wellness checks or guest management. To ensure consistency and alleviate administrative pressures when making these required updates, an example approach could be that at the review stage, you organize agreements by type or by date that they are entered into to attempt to identify common terms. This could include looking at tenancy agreements entered into before and after the recent 2024 changes, because we're assuming those would be different. When updating and drafting terms, It may be of interest to create separate terms that differ based on programs that you offer, based on building policies or other common elements. This could ensure that the terms being updated will meet operational requirements, tenant needs, and legal requirements as far as clarity and consistency with the Act and conscionability and fairness. Once you review and update terms, and those are complete, an automatic next step would be to update templates to include these new required terms. This will ensure that any new tenancy agreements have terms that are needed and that they meet the legal and operational requirements of that site. And finally, a process should be developed to prepare staff for notification and documentation requirements of the amendment process. Having an in-house process for this step will ensure that notice and service requirements are met and that proper records are kept to prove these steps. So at a minimum, as a reminder, the notification about the new standard terms is required for all agreements. So as we had alluded to earlier, there were questions about transitional versus supportive housing. And so your next steps really depend on whether you are operating the tenancy or unit under the Residential Tenancy Act or not. So if you're operating supportive housing with tenancy agreements, then the process we have just discussed has been developed to assist you to update your agreements. You should issue the RTB notice of agreement amendment for any existing tenancies and ensure that the new terms are included in any new tenancy agreements going forward. You do not need to reissue agreements for existing tenancies, right? It's just the notice, as well as the tenant fact sheet. It's not mandatory, but encouraged. If you're operating supportive housing with program agreements, then the process is the same. Since the unit or tenancy are under the Residential Tenancy Act, the new process applies to the tenancy, regardless of whether the tenancy is via a tenancy agreement or a program agreement. In either case, the RTB notice of agreement amendment should be issued for existing tenancies, and the new terms should be included in any new program agreements going forward. You do not need to reissue any agreements again for those existing tenancies. Now, if you're operating transitional housing with program agreements, then the units and tenancies do not fall under the Residential Tenancy Act, and therefore these changes do not apply to you. It is, however, best practice to ensure that you have within those agreements the required guest and wellness check terms. And if you're unsure whether the units and tenancies are supportive housing or transitional housing, you should seek independent legal advice. If this does not provide the clarity to confidently move forward with one of the previous approaches, you should ensure that your agreements include guest and wellness check terms if they do not already. Since the RTB notice of amendment form can only be used for supportive housing, you should not use this document for any changes you make to those agreements. Rather, you should proceed with an amendment as per your current amendment process. So on this last slide, before we go to questions, we have the different resources that were provided to aid in the amendment process. Now, as it pertains to additional terms, providers can refer to the operational standards for guest management wellness check policies. That's the second one from the top, as well as the BC Housing templated additional terms. And then you would be looking to update your additional terms and serve the notice when required. In addition to these documents, we have listed a FAQ. We also will be developing other operational guidance documents to help ahead of the December 1st effective date for the new tools. Now, we understand that these changes will create real pressures, and we have purposefully offset the effective dates of the new tools for this reason. So as much as they're immediately needed, the tools will be effective as of December 1st. And so thank you for your patience. I know it's a repetitive presentation, but we'll now open the floor for questions, and I'll stop sharing.
Thanks so much for that, Leon. Really appreciate you taking the time to walk folks through it. I think most of us resolved the audio piece. I apologize again. It turns out that Zoom does an assessment if you come in through a web browser of the strength of your Wi-Fi and then decides that you should be audio only. So that was creating a very bizarre issue for a lot of people, which we couldn't fix on our end and you can't seem to fix on yours. So anyways, just a note again that the presentation was recorded. I'll get Courtney to stop recording it too now for the Q&A section when she gets a moment.